Okay, welcome to Resolving Financial Abuse Legal Issues, a webinar presented by Redfern Legal Centre. My name is Nick Manning and I coordinate the Community Workers Training Program here at RLC. Jasmine, would you like to introduce yourself?
Sure, I'm a solicitor in the Financial Abuse Service New South Wales at Redfern Legal Centre, which is our statewide service assisting clients who've experienced financial abuse in intimate partner relationships, which was launched in 2019.
There's Jasmine. I'd like to acknowledge the Gadigal people of the Eora Nation, who are the traditional custodians of the land that Redfern Legal Centre's office is based on. Currently, we have staff working remotely, so they're working on the land of a number of different nations, Aboriginal nations. I myself work on Gadigal land, but wherever you're working and living, I'd like to acknowledge the traditional custodians and pay respect to elders, both past and present, and extend that respect to other Indigenous Australians who may be present. So Jasmine, would you like to give us an outline of what you're going to be presenting and kick off the webinar?
Thanks, Nick. So what we'll be covering today is an overview of consumer credit law. Now this will be quite heavy on the law and I've included references to the legislation where appropriate so that you've got that in your slides, but I won't spend too much time delving into it. I know from the pre-poll that we've just done that we've got more than half of our participants today are financial counsellors, and we've got about 10% solicitors joining us and then a lot of community workers. So I'll try and pitch it at that sort of level. Then we'll have a chat about how to craft financial hardship requests to try to get the best outcomes for your clients. We'll run through some tips and tricks for negotiating with creditors and debt collectors, which we've gained through running our financial abuse service. And then we'll finish up with when and how you should be looking to get specialist legal advice, finally questions and further resources.
Okay, our first topic is consumer credit law, and will we go straight to the quiz? Okay, so we've got a quick quiz for you to test your knowledge. It will appear on your screen, and if you could answer those questions to the best of your knowledge. This isn't really a test of you, it's to give us an idea of the knowledge level that's out there. If you're watching the recorded video, if you'd like to answer those questions in your own head, and we'll put up the answers in a moment. So we'll just give you about 1 minute to answer those to the best of your ability. I don't have any music, any thinking music. I'm not going to sing. So we'll just give you a few more seconds to answer questions there. It's okay if you don't get through the whole quiz. Okay, so I'll end the poll and we'll see what people had. Okay, so you can see the results on the screen. I might read out the general result and then Jasmine, if you want to give the correct answer. So the first one, financial institutions are legally required to consider requests for hardship assistance. So almost everyone said that's true, Jasmine?
Yeah, so that's right under the National Credit Code. And even if the code doesn't apply, for example, because your client is a small business borrower, you can always check whether the lender is bound by the Code of Banking Practice, the Customer-Owned Banking Code of Practice, which applies to credit unions, or a member of the Mortgage and Finance Association. These codes all have their own obligations to work with borrowers in financial hardship.
Okay, Number 2, if a creditor rejects a request for financial hardship assistance, there's nothing you can do about it. Now, everyone said that was false.
Yes, that's great. So you all correctly answered that if the creditor hasn't complied with their obligations under the National Credit Code, you can make a complaint to AFCA, and AFCA can actually decide on the appropriate repayment arrangements. And all lenders, finance brokers and mortgage managers who arrange or provide credit must be members of AFCA. That's the Australian Financial Complaints Authority.
Okay, number 3, a creditor can remove a default listing from a customer's credit report where the customer has experienced financial abuse, even if the listing is correct. And now about 4/5 of people said that was true.
So that is true. I think the 1/5 there is, it is sort of a bit of a trick question. Although creditors aren't legally required to remove the default listing unless the entry is incorrect, it is actually considered good industry practice in circumstances of financial abuse to remove the default listing regardless. And this is reflected in AFCA's approach to joint facilities and family violence, which we'll talk about later.
Okay, number 4, if a creditor has already obtained default judgment against your client in court, there's nothing your client can do but pay the debt. Now, about 4/5 of people said that was false.
So again, that's right, this is false. At least in New South Wales, you can apply to the local court to set aside the default judgment, and this will give your client an opportunity to defend the original claim. You can also reach out to the creditor directly to try to negotiate a reduced payment or a payment plan, and in most cases, they'll see this as a better option than spending more time and money and resources to try and enforce the debt.
Okay, number 5, if your client has received a statement of claim, it is too late to make a complaint to AFCA. 90% of people said that was false.
Correct, so that's false. In these circumstances, we would often lodge a complaint with AFCA as soon as possible because this will actually pause all enforcement action until the matter has been dealt with by AFCA. So that means that the lender can't apply for default judgment or commence any new court proceedings against your client for the debt while it's at AFCA.
Okay.
So the consumer credit law in Australia is national legislation and has 2 main parts. The first is the National Consumer Credit Protection Act, which we call the NCCP, and the second is the National Credit Code, which is actually housed within the NCCP Act. And unless stated otherwise, all references in these slides are to sections of the NCCP, so that's the main act. Where a reference is to the National Credit Code, it will have the letters NCC after it. Now, you will sometimes come across credit contracts that were taken out prior to July 2010. And in that case, you should seek specialist legal advice because different laws would apply to that credit contract, and they were state-based laws at that time. So what sort of contracts do the credit laws apply to? They're consumer loans predominantly for personal, domestic or household purposes. So the typical contracts we would see are car loans, personal loans, home loans, credit cards, and consumer leases like rental contracts for goods. In some circumstances, you might have a credit contract that has a business purposes declaration that's been signed by your client, or the contract might state for business purposes only, or your client might just have a business loan. And in those circumstances, you should get legal advice to see whether the credit law does in fact apply, or what your client's options might be if not. Now, this might be relevant in circumstances of financial abuse where your client has been coerced into signing a credit contract, and that could be a joint contract or it could be in their name only. Your client's signature could have actually been forged on the loan documents in a case of fraud. Sometimes your client might not have gotten any benefit from the credit contract, but it might be in their name. And we see this often with car loans, where their partner has actually registered the car in their name and had the full benefit of it, but the car loan is in our client's name. There might be cases where your client didn't understand the terms of the contract, or, and this is a big one, that your client couldn't actually afford the contract at the time it was approved. Now, to give you a quick overview of the responsible lending obligations in the credit laws, the starting position is that credit providers must not enter unsuitable credit contracts, and they have to assess the unsuitability of the contract before entering into it. So how do they assess whether a loan is unsuitable for a consumer? They're required under Section 130 to make reasonable inquiries about the consumer's financial situation, make reasonable inquiries about the consumer's requirements and objectives in seeking the loan, and take reasonable steps to verify the consumer's financial situation. And we'll explore each of those bolded terms in a bit more detail. So the Act considers that a loan will be unsuitable if the consumer can't meet the financial obligations under the contract, or they can't meet those financial obligations without substantial hardship. And we'll look at that more closely in a minute. It will also be unsuitable if it doesn't meet the consumer's objectives and requirements. So one example for that would be a customer taking out a car loan if they don't even have a driver's license. And it leads you to wonder how a car loan could possibly meet the consumer's objectives and requirements. A similar situation is if a client goes to a bank looking to take out a credit card for, with a $3,000 limit, and they walk away with a credit card with a $20,000 limit. The remedies that consumers can seek for breaches of the responsible lending conduct include changes to the contract and compensation under sections 178 and 179.
A couple of things from me. Just a reminder that if you have questions, please use the Q&A panel. If you can type your questions in there rather than raising your hand, and we'll deal with some of those as we go, and we might hold others till the end. Jasmine, I had a question about the second bullet point here. It strikes me that it might be incredibly common for in a couple for a loan to be in one person's name where the other person gets the main benefit, and a car is an obvious example. Are you saying that that's sort of intrinsically a breach of the code, or what's the situation here?
So obviously one of the difficult things with assessing cases involving financial abuse in intimate partner relationships is that there's obviously a line between financial abuse and between couples choosing how they manage their own finances and how they share debts and assets in the relationship. So what this is looking at is whether the consumer who was actually applying for the loan did so without coercion. So it was, of their own free will, and they weren't pressured to do so by their partner. And that, they might well have had the objective of securing a car loan for their partner's primary use, as long as that was entered into willingly without coercion, and they haven't been under any misapprehension, I guess, about who bears the liability for that loan.
So Bex asked, what about a client that's been named on a home loan but not on the title for the property?
So that's a good question, and it's similar to the question Nick just asked, where there are many legitimate reasons why a couple might decide that they're both on a mortgage and they're both jointly and severally liable for that mortgage, but only one of them is on the title. But if that's a situation where your client has been misled as to whether they have a legal right to the property, or they have found themselves, perhaps with sole responsibility for the mortgage in circumstances where they shouldn't have been, that's often a situation that we see resolved through property settlement in family law after the relationship ends.
Okay.
So what are reasonable inquiries? Helpfully, this is not actually defined in the legislation, but ASIC has given some guidance on what these obligations require, and the best source for that is their Regulatory Guide 209, which is available on our resources page on our website. Now, the law in this area is still developing, and it's often decided on a case-by-case basis. At the bare minimum, there does need to be some attempt to verify the client's income and living expenses. And typically you would see lenders requesting evidence of pay slips, account statements to show their income coming in, that they can actually afford the contract. And in some circumstances, leases and credit card statements to show their expenses. I've just seen a question come up about the recent Westpac and ASIC case, which is something that I'll touch on in a couple of slides, but that is a perfect example of the fact that the law is still developing, and we are waiting for ASIC to provide further guidance in light of that decision, and I expect that there might be some changes to the RG 209 in the coming year or so, because they did update it at the end of 2019 after the federal court's decision in that case. We've also had a question about what if clients are pressured into taking out loans? That's a perfect example of where they might be coerced to take out a loan for their partner's benefit, and where we would be doing a deep dive into the documents and the circumstances of entry into that loan to see what the credit provider knew or should have known, and whether they should have identified warning signs of financial abuse, which I'll come to in a moment. Now, what are the consumer's requirements and objectives? This is another example where the lender needs to make reasonable inquiries to comply with their obligations under the credit laws. A couple of examples that I mentioned earlier would be, a car loan for someone who doesn't have a driver's license and can't possibly benefit from the car that's secured by the loan, and a credit card with a much higher limit than what the consumer is looking for or what they can afford. Now, the unsuitability assessment is something that credit providers are required to do before they can satisfy themselves that the credit contract is not unsuitable for the consumer. So it's a bit of a double negative, as we often find in legislation. The starting point is that the consumer will be unsuitable for a credit contract, any credit contract covered by the Act, until the lender assesses that they're not unsuitable.
You got to love lawyers. Can
Exactly.
I just say that?
Exactly. Now, as was addressed in a question we just got, the most recent case law we have on this is from the ASIC and Westpac case, which is commonly known as the Wagyu and Shiraz case, where the federal court considered the use of benchmarks to calculate a person's living expenses and therefore how much they can afford. Now, in the federal court decision, Justice Parham found that a lender can basically do it at once in the assessment process. ASIC filed an appeal, which was recently dismissed by the full court of the federal court, which leaves us with the current legal position on this matter, which is really that the unsuitability test is meant to avoid harm to the consumer. So the focus is not on the credit provider actually judging whether the consumer will benefit from borrowing. It's really making sure that they won't be harmed. So it's kind of a negative test rather than a positive test. And the current legal position coming out of the most recent decision from the full court of the federal court is that a credit provider really has flexibility over how it chooses to conduct its unsuitability assessment. And there's also no obligation to use all of the information it collects from the consumer. We've got a question here that what happens when a client signs a contract that their income and expenses are correct, but no verifying documents were requested or given. Again, from the ASIC and Westpac decision, it's up to the credit provider to decide how they satisfy themselves in order to complete their unsuitability assessment. But we would be making arguments if they accepted on face value that the client had a certain income, but they had no reasonable basis to accept that, and they hadn't made reasonable inquiries, then there is definitely the argument there that they haven't complied with their obligations. Obviously, the credit provider is likely to come back and say, well, we were satisfied and we can do what we like in the process. But there does need to be some bare minimum. It's not prescriptive in the legislation, it's not defined, but there will always be an argument about the credit provider basically being able to satisfy themselves and you that they've done enough. And just finally, how do you know whether this assessment was actually done, let alone done correctly? Under the legislation, the assessment has to be provided within set time periods on request. So if the contract is less than 2 years old and you request a copy of the unsuitability assessment, they have to provide it within 7 business days. Otherwise, if the contract is up to 7 years old, then they have to provide it within 21 business days. We've got a question. If a credit provider cannot provide a copy of the assessment, is a retrospective assessment deemed an acceptable alternative? We do sometimes see this where a credit provider might provide a document that is clearly backdated and they say on, the 12th of September in 2017, we assessed this contract was not unsuitable. They could well have their own internal systems and processes, and they may not necessarily spit out a record of their unsuitability assessment every time they do one. The question would be whether you have reason to believe that they didn't do one at the time, which would be a breach of the Act. And if they don't provide one at all, then there's a strong argument there that they actually didn't do one unless they can show otherwise, which is also a breach of the Act. We've got a question. Did the use of brokers impact on all this? The banks seem to wash their hands of this because brokers were responsible. And if they didn't do this properly due to high commissions, then it's not their problem. The involvement of brokers is a difficult one, and that's something that we see come up a lot in AFCA complaints, where the credit provider naturally will try to wash their hands of it and defer responsibility to the broker, and AFCA will sometimes take the same position. However, credit providers have their own obligations, as do the brokers. And while credit providers can rely to a certain extent on information that is collected by the broker and then packaged up neatly and provided to them, they still have to satisfy themselves that it's not unsuitable for the consumer and make a certain level of reasonable inquiries themselves. So it's still an argument that we run even where there's a broker involved. And we often have cases where the broker who's been involved in securing a mortgage, for example, is actually a close acquaintance of our client's former partner and the perpetrator of the financial abuse. So in those circumstances, we will explain quite clearly to AFCA or to the credit provider that there are risks to our client's safety and very compelling reasons for why they would not be inclined to pursue the broker and why they've decided to take action against the bank themselves.
Okay, Shane has a question about buy now, pay later. Do you want to deal with that now or later?
I'll deal with that a little bit later.
Okay.
I'll finish this section first. So substantial hardship, again, is not defined in the legislation, but a couple of key examples are if the person can't afford to keep up mortgage repayments without selling their family home. That's actually a specific example given in the credit laws. And as of the 1st of January 2019, if the person can't pay off the limit on their credit card at the highest applicable interest rate within 3 years based on their income, then that credit card will be considered to be an unsuitable contract for the consumer. And remember that under Section 131, if the consumer can't meet the financial obligations under the contract or can only do so with substantial hardship, then the contract is considered to be unsuitable and the credit provider is actually legally prevented from entering into that contract. In order to assess this, I suggest referring to the credit law toolkit produced by Legal Aid and the Financial Rights Legal Centre, which is listed in our resources, as well as the Regulatory Guide 209 for guidance around serviceability and what's expected of lenders in order to comply with their obligations. Now, in order to make all of these assessments, you'll obviously need some documents. And in many cases where your client has experienced financial abuse and other forms of domestic abuse, they may not have all the documents you need because the perpetrator may have withheld them, your client might have fled quickly and didn't have time to get the documents, or it might not be safe for them to go back and collect them. So your client, or you on your client's behalf, can request copies of loan documents and account information under the National Credit Code. Usually written authority will be required if you're doing so on behalf of your client, and banks naturally have quite stringent restrictions around who and how they provide personal information. When requesting these documents from creditors, we would always include a request for a hold on any collections action so that by the time the client or you gets the documents back, you've actually got time to review them and give the client advice. That there's no sense in getting documents back if the credit provider is going to turn around and start taking action for the debt.
There's a question about evidence. A credit provider is required to provide evidence of the documents, e.g. pay slips, which we use to complete the suitability assessment. Yes,
so under Section 132 of the NCCP Act, that sort of falls under the category of the application form, the unsuitability assessment, as well as supporting information that was relied on at the time. So they can't just provide you with the application form and say, oh, we had really good reason to believe that the client was earning $300,000 a year. Now, something to be aware of when you're requesting documents is the time limit on recovery of debts. So in most cases, the credit provider has to take court action to recover a debt within 6 years. And this 6 years can be reset anytime the debtor, so that is your client, makes a repayment or acknowledges the debt in writing. So even if it's been more than 6 years since the debt first arose, if halfway through that period, say 3 years ago, your client paid $10 off, or your client spoke to them and then sent a follow-up email and said, oh, I'm just writing to you about my debt of $20,000, then that will reset that 6-year time period. So be really careful when you're advising clients to seek information or request a waiver from a creditor that you're not acknowledging that the client owes the debt, and that you're expressing the request as, solely a request for documents. And also be aware that this time limit is a defense for your client. There's nothing actually stopping the creditor from having a go and trying to recover the debt after 6 years. But your client might have a complete defense to the debt. So it would be up to your client to raise the Limitation Act defense if it applies. Now to the question that we had earlier about, supporting information and the documents that credit providers must provide. These are the sections of the Act, so either the NCCP Act or the National Credit Code, which set out obligations for credit providers to provide certain types of documents on request. And the time periods as well. Keep in mind that you might need to send any requests to the original creditor and the debt collector. In my experience, the debt collector will typically only have the notice of assignment of debt, so when the debt was actually sold from the credit provider to them, and they might have some outstanding bills and default notices, but they typically won't have the original documents that you're after, like the application form, the contract, the unsuitability assessment. Those are the documents that you'll need to assess whether there are any breaches of the credit laws. And another note that these time periods in that far right column only apply to written requests for documents, not verbal requests over the phone, for example. And at the moment, you may need to be lenient because there are significant delays due to COVID.
Now, Lucy read my mind. I had exactly the same question, which is what about information when it's a joint loan? Lucy's had creditors say they can't discuss as there's not consent from both parties.
So if it's a joint loan, meaning that your client is jointly and severally liable for the loan, then your client as one of the borrowers, even though they're a co-borrower, is entitled to access all of this information because it makes sense if they're liable for this loan, it will appear in their credit report. It affects their financial position and they are legally required to repay the loan, then they are of course entitled to all of this information. In those cases, we've actually never had any trouble that I can think of getting documents for joint loans, but in many cases on the application form, for example, the credit provider will redact the other party's details or details of the other party's income and things like that. There's also a specific obligation, I guess, for the credit provider to work with individual borrowers to assess requests for financial hardship, for example, which we'll get to later. So just because it's a joint loan and there is another co-borrower shouldn't stop your client from accessing any information or making requests for hardship assistance or dealing with the loan in a way they would if it was only in their name. Now, once you've got the documents back and the credit provider has put a hold on the debt while you're reviewing the documents, what are you actually looking for? We've got some suggestions here for, I guess, red flags, including where the income listed on the application is higher than your client's income at the time, and you'll usually have to go through the documents with them and verify everything. You might see that your client had no income or only had Centrelink income at the time of the application, but the credit provider considered that the contract was suitable for them. Obviously, depending on the size of the loan or the nature of the credit contract, that might be a warning sign. You might find that other debts or liabilities aren't listed or they're not accurately listed. And there are instances, it's hard to believe, but there are instances where a credit provider will issue a second car loan to a customer who already has a car loan with the same finance company, and they won't take that into account in their assessment. You might see that the contact information listed doesn't match your client. We'll often see that the loan or the credit contract is in our client's name, but the phone number, the email address, the address, all of the details actually go to their ex-partner. So they were listed in name only and they bore the full liability for the contract, but it was all organised through the ex-partner, and that was quite clear on the application.
Christine asks, as a guarantor, are you entitled to the same rights to the documents as the lender is?
So as a guarantor for a consumer loan, you have certain rights, but they're moderated, I guess, by the fact that credit providers are required to issue a warning of sorts to a guarantor before entering into the contract. But you are entitled to these documents as a guarantor because obviously you're liable for the debt if the debtor, so the borrower, reneges on their obligations under the contract. So if you've guaranteed a debt and the credit provider is threatening to come after you because the debtor hasn't repaid, yes, you are entitled to see those original documents, and you might approach the debt in the same way as a borrower would in terms of looking through, seeing whether they made the correct assessment at the time and whether they could have issued that contract to the borrower. There are tricky situations with companies that basically make their money from guarantor-only loans. And so while they will assess the borrower's income and expenses in determining suitability, they will also consider the guarantor, obviously, in whether the loan is serviceable. So that's a tricky situation. And in those circumstances, obviously, both the borrower and the guarantor are on the hook.
We've got a question about removing one of the names from a joint mortgage or property. Do you want to deal with that now? Is that later?
So the question was, if there's family violence or elder abuse, but the mortgage is in joint names, what steps would need to be taken to get the other party's name removed from the mortgage or property title? This is something that we don't deal with in terms of responsible lending or the credit laws. It's typically something that would be addressed through family court. And the family court might make orders for a name to be, for the property to be transferred, or for a name to be added to the title to reflect contributions made by both parties in the relationship. So that's more a family law question.
Also the mortgage?
So being removed from the mortgage, that's a difficult situation where you might be able to show that even though your client's name is on the mortgage, the other party has actually been paying the repayments. And so you might say, look, it's really their mortgage and I don't want my client's name on it. But in those situations, the credit provider might be stuck between a rock and a hard place, because you might be asking them to refinance the mortgage only in the other person's name and to take your client's name off. But it might be that the only reason the mortgage got through in the first place was because your client's name was there as well, and they could rely on your client's credit history. So you might be asking them to refinance the mortgage and actually breach their responsible lending obligations by issuing the mortgage solely in the other person's name, when the other person might not be able to repay the mortgage without substantial hardship, as we've discussed earlier. So that sort of refinancing issue is definitely something to raise with the bank, but the bank will obviously need to conduct their own unsuitability assessment and basically consider it as a request to refinance solely in one person's name. So,
and that might lead to foreclosing, or?
So it depends on the situation, obviously, but most credit providers will be very wary to refinance on the request of your client rather than the person who's ultimately going to end up with the mortgage. And what you might be looking at in those situations is an agreement from the credit provider. So the bank, for example, like a deed of forbearance or an agreement not to pursue your client for the debt, but your client's name might have to stay on the mortgage. So there are some creative ways to get around that, but it's definitely a complex issue.
And it sounds like, thinking about mortgages, this mortgage might continue for 20, 25 years. And to have your name still on there and some sort of agreement not to pursue you, I guess would make people nervous.
Exactly. It's often not a satisfactory outcome. In many cases, if there are family law proceedings, then the property might just be sold and the mortgage dealt with that way and discharged. But if you do manage to get the credit provider to agree not to pursue your client for the mortgage, but for your client's name to stay on there, obviously that will still appear in their credit report and will impact their future lending. So you might also be wanting to get a deed or a written confirmation, I guess, from the lender that your client could then provide when they're seeking future credit contracts. So some other things to look for in the documents are when no inquiries were made about your client's income and assets. So the lender didn't check that payslips were valid. If your client had no contact with the lender at all, or very limited contact, or it was mostly controlled by their partner, or the credit contract almost entirely eroded equity in a secured asset like a car, like a house or a car. I'll try and whip through these last bits quickly so I can get to the, I guess, the negotiation tips. But you'd want to be asking your client about what level of interaction they had with the credit provider, the broker if relevant, both when they took out the credit contract and throughout the life of the contract. And we've got here just a list of some warning signs of financial abuse that are recognised by the Australian Banking Association's industry guideline, and also echoed in AFCA's approach to joint facilities and family violence. So you can have a look at that in our resources list. Now, it's easy to take financial hardship at face value, but often with financial abuse matters, we need to dig deeper and ask questions about whether there's anything the lender knew or should have known at the time of issuing the contract. So a helpful way of thinking about it is whether your client couldn't afford to pay the loan when it was originally obtained, which might lead you to consider making a complaint about breaches of the responsible lending obligations in the credit law. But the other situation might be that your client could afford the loan at the time, but then their circumstances changed and they now are not able to afford it, in which cases it might be a more straightforward situation where you'd be seeking financial hardship assistance. Obviously, in the community sector and financial counselling services, we all know well that there are often resourcing issues. So if you get to this point and you've identified that financial abuse has occurred and there are some complex legal issues and you think it maybe falls into that first dot point, but you don't have capacity to do that time-consuming work, making complaints to individual creditors, rather than just sending off requests for hardship assistance and dealing with it that way, we would strongly encourage that you consider referring the client for specialist advice. We're very happy to take referrals for these matters, or you might be able to refer the client to another specialised legal service, just to explore whether there are any options available besides bankruptcy or financial hardship requests. Now, the remedy available will depend on the circumstances of the case. Generally, the principal of the loan still needs to be repaid, but the credit provider might need to refund any fees, interest and charges that they benefited from issuing the contract. And you might need to take account of any benefit the borrower did receive. So for example, if they accessed additional equity in the family home, but they did use a portion of that on renovations, which increased the value of the home, then you would have to take that into account. Creditors will often agree to waive the full amount owing on a no admissions basis just to make the complaint go away. And this might be a better outcome for your client if they haven't actually repaid much of the principal yet. Now here are just some outcomes to think about. So we've got some examples there of reducing the amount to pay, so a full or partial waiver of interest or fees, severing liability, which we've discussed already, cancelling a telecommunications account or contract, or a refund. You might be looking to extend the time to pay, so maybe not reducing the total amount, but extending it over the life or over a longer life of the loan. And in the bottom right, we've got credit reporting. So as mentioned earlier, it is good industry practice to remove adverse credit information where there's been financial abuse. Now, the time limit for taking action in relation to breaches of the responsible lending obligations is 6 years from the date of the breach. And if the conduct, which is typically the issuing of the credit contract in the first place, so the approval process, if that occurred more than 6 years ago, then you might be left with making an application under the unjust contracts provisions, which I'll whip through very quickly. So unjustness is defined in the National Credit Code as unconscionable, harsh or oppressive conduct. And in circumstances where a contract is unjust, a court might agree to reopen the credit contract or mortgage or guarantee. They can also review unconscionable interest and other charges. Now, in determining whether a contract is unjust at the time it's entered into or changed, the court will usually consider the public interest, and all the circumstances of the case. So I won't go into this, but on this and the following slides, we've got some examples that might be relevant in assessing unjustness. So the bargaining positions of the parties, whether there was any negotiation. If you go to the next slide, in terms of our clients that we see, it's often relevant whether the contract was explained to the consumer and they understood it, whether they had the chance to get independent legal advice, and this second last dot point, whether unfair tactics or pressure were used on the consumer. Then we've also got examples where there are excessive interest and fees when compared with other similar loans, or the credit provider knew that the consumer couldn't repay the loan but entered into it anyway. So those circumstances aren't exhaustive, and there are situations where a contract will still be unjust when none of those factors apply, but it's just the vibe of it in all the circumstances of the contract. So that's also something to think about if you've got a matter where you've gone past the 6-year time limit for responsible lending complaints.
So the vibe of it is a legal term.
I've borrowed that, but
it is where you borrowed that from.
But it is really true with unjustness that it's sort of a catch-all. So don't be limited by those examples on those previous slides. Now, again, remedies for unjust contracts will depend. They'll usually need to repay that benefit. But the principle is that they should be put back in the position they would have been in, but for the unjust contract. And the time limit for unjust contracts claims is 2 years from when the credit contract is rescinded or discharged. So that's something to keep in mind if you've got a mortgage or a credit contract that is still on foot, that time limit only starts running from when the contract is discharged. And if the loan has been refinanced along the way, particularly with different lenders, keep in mind the time limit expiring on any previously refinanced loans. Now, external dispute resolution is a free service for resolving disputes between consumers and members of the scheme. There are different schemes for different industries, but membership is compulsory for most industry participants. So lenders, banks, mortgage managers must all be members of AFCA, and it's actually a condition of them holding an Australian credit licence. EDR is a really good alternative to court if you're not able to resolve a dispute directly with the credit provider through internal dispute resolution. It's quite consumer friendly, it's free, it's not as formal as court, and it's very low risk, but there are time limits for making complaints. Now, this is a quick overview of the EDR schemes. We've got AFCA, which applies to most consumer credit contracts, then the Telecommunications Industry Ombudsman for telco contracts, and E1 for utilities. As I touched on, the benefits of AFCA are that it's free for the consumer, there's no risk of any adverse costs orders, there are no formal rules of evidence, and as mentioned earlier, there will be a hold on enforcement action. So while the matter is being considered by AFCA, the creditor can't commence or continue legal proceedings, they can't list the debt for default on your client's credit report, and they also can't sell the debt to a debt collector. And AFCA can actually make repayment arrangements. So vary the credit contract under the credit law if they consider that the credit provider hasn't been working with the consumer to reach an arrangement for financial hardship. Again, there are time limits that are relevant, so keep these in mind if you're making complaints to AFCA. And it is the later of either 2 years from when the credit contract comes to an end or 2 years from when a final response is given at IDR. So usually the credit provider in their final response letter will say, if you don't like our response, you can go to AFCA, but be aware of the time limits. That 2 years is the time limit that you need to be aware of there. Now, these resources that I've touched on earlier are all available on our website, and definitely have a look through these if you're looking at some of these cases and you've got all the documents back from the credit provider and you're trying to assess whether there might be any breaches of the credit laws. Okay,
do continue to send your questions in, but we're going to hold the rest of them until the end, just so we allow for the time needed. So our next topic is how to craft financial hardship requests.
Okay, so as we've touched on, credit providers do have a legal obligation to provide financial hardship assistance to a debtor who can't meet their repayments because of illness, unemployment, or other reasonable cause. This is a very wide definition. Reasonable cause can include reduced employment, family breakdown, family and domestic violence, or leaving an abusive relationship. And they can seek financial hardship assistance either verbally or in writing. We would usually suggest doing it in writing so that you've got a record of the correspondence. Now, AFCA's guidelines are that credit providers should be fast-tracking financial hardship requests where domestic and family violence is disclosed. And they should also have specialised staff within their financial hardship teams to assist survivors of domestic and family violence. As I mentioned earlier, AFCA recognises that because each borrower is in a joint loan is jointly and severally liable for the full amount, they're also individually entitled to ask for assistance if they're having trouble meeting their obligations. So if the credit provider says, we can't consider a request for hardship assistance or a waiver or whatever it might be without the co-borrower's consent, you should explain that the customer has experienced financial abuse and family violence and really push back on that. The co-borrower's financial circumstances also shouldn't be taken into account. So the fact that they might have plenty of assets sitting there doesn't impact the fact that your client is unable to comply with their obligations under the contract. Now, credit providers have to respond to financial hardship requests within set timeframes. Within 21 days of receiving the request, they can ask for more information. This would typically be a statement of financial position or other evidence of the client's financial circumstances. And they also have to respond to the hardship request within set timeframes and give reasons for their refusal and the referral information for AFCA. They also can't commence enforcement proceedings until 14 days after they've refused hardship assistance. So keep in mind that it is a legal obligation to consider these requests. They don't just do it out of the goodness of their hearts, and you can require them to get back to you within a certain amount of time or follow up if you just haven't heard. Now, if the credit law doesn't apply, for example, because you're dealing with business leases or investment loans, as I mentioned earlier, there are still obligations found in other sources to provide financial hardship assistance. And if the credit provider is a member of AFCA, you can always still make a complaint to AFCA. So how would you go about drafting a request for financial hardship assistance? We typically start with a safety warning explaining that the client has experienced family and domestic abuse. And particularly where it's a joint loan, we ask them to use caution, confidentiality and sensitivity with the information we're giving them in order to protect the client's safety. And we'll often specifically ask that they don't provide a copy of the letter to the co-borrower or any third party. We would then go into a brief description of the relationship and the financial abuse and a description of the client's financial position to explain why we're requesting hardship assistance. And then request the actual remedy we're seeking. So is that a full waiver of the outstanding balance, a partial waiver? Does the client just need more time to pay? Again, we would always request for the removal of the default listing if there is one on the client's credit report or any adverse credit information, and enclose any supporting evidence. There's no legal obligation to provide an AVO even if one exists, and credit providers shouldn't be requesting that. But you might want to get ahead of them and provide an AVO if the client's comfortable with that, as well as, a statement of financial position to kind of head off the fact that they're likely to request that.
And we may have touched on this in the first webinar, but if there's been no actual physical violence, but there's financial abuse, does that change anything in this area? No,
it doesn't change anything. And if the credit provider is insisting on an AVO, you can refer them to the AFCA guidelines that AVOs shouldn't be required. There are similar guidelines from the telecommunications industry ombudsman if you're dealing with a telco. And you might also want to remind them that at least in New South Wales, AVOs and protection orders aren't available for financial abuse alone. And some examples of supporting evidence you might want to provide. As I've mentioned, a protection order shouldn't be required, but you might want to provide it. And feel free to to remind institutions of that if they're being quite insistent on that and asking for, in their words, evidence or supporting evidence of the financial abuse and domestic violence. Now, the responses you might get, you could get a successful resolution straight away, in which case you might be looking at whether there should be a settlement deed to confirm that and have it executed by both parties to protect your client's interests moving forward. Make sure that any outcome is in full and final settlement of the debt so that the credit provider can't continue to come after your client later. And again, always make sure that any adverse credit information is removed. If you aren't able to agree, you might continue negotiating directly with the section of the credit provider you're dealing with. You might refer it for internal dispute resolution, or you might escalate it then to external dispute resolution through AFCA. You might also want to refer your client for specialist legal advice if they haven't already got it, to see whether there are any other avenues to consider. Okay,
our next topic, tips and tricks for negotiating with creditors and debt collectors.
Okay, so this is a reminder of some general tips from our previous webinar. I encourage you to go back and watch that for much more detailed explanation of getting this information from your clients. As I mentioned earlier, you should generally request information from both the creditor and the debt collector. You will want to ask your client for any documents they have, but typically they won't have much, and you'll need to go directly to the source. And always request a hold on any collections action while you're waiting to get those documents. We encourage you to establish authority with the stakeholder as soon as possible, and ask them about their domestic violence or financial abuse or financial hardship policies, because these may not be publicly available. As well as establishing your own authority with the stakeholder, you should check whether the abuser, so your client's partner or ex-partner, has authority to contact the creditor on their behalf, particularly if they were involved in negotiating the credit contract, and revoke that authority so that they can't get further information about your client or make any changes to the contract. You can also proactively start to gather evidence of your client's circumstances and financial position. Now, when you're approaching a credit provider, I would always suggest including details of your client's financial hardship, even if you're making a consumer complaint about responsible lending breaches, because in many circumstances, the credit provider will make their decision on the basis of both trying to get rid of a potential complaint, but also showing that they can exercise compassion and maybe waive a debt in recognition of the fact that both your client is in financial hardship and that it's likely to be very difficult for them to actually recover any money from your client. Obviously, you'd want to start with the most favorable outcome for your client and negotiate down from there, but be clear about your proposed remedy. Don't just wait for the credit provider to offer a solution. If you are of the view that a full waiver would be appropriate and that would be the best outcome for your client, then start with that so that the credit provider has something to respond to. And again, I'll hammer on about this, but think about long-term consequences of that credit contract on your client's future lending capacity, and always request the removal of default listings.
Okay, next topic, negotiating with financial service providers.
So these are some of the industry guidelines available on our website, which you would be reading through and finding anything that's helpful to your client's particular matter. They don't have legal force or prescribe binding obligations on banks or creditors, but they do describe industry best practice. So think of it as an insight into how banks and other financial firms have agreed to approach financial abuse and domestic violence. They are voluntary guidelines, but they're developed with input from member banks and firms, and they're encouraged to use these guidelines when developing their internal processes. So if you're dealing with a creditor and you find that their internal policies aren't consistent with these guidelines, then call them out on it and work with them to achieve a better outcome for your client. Again, most financial service providers will have internal policies for financial hardship and domestic violence, but they might not publicize them on their websites unless you ask for them. And some major banks have also started publishing guides on financial abuse, which are also available on our website. Now, these policies and guidelines set out some expectations of best practice, including that staff should be specially trained to recognize and respond to warning signs, that they should take disclosures of domestic and family violence at face value and not require evidence like protection orders, that they should provide copies of account documents free of charge in recognition of your client's circumstances and likely financial hardship, and that once they're notified of domestic and family violence, they shouldn't then go and sell that debt to a debt collector. Now, responding to warning signs of financial abuse might include making further inquiries before approving the contract, or speaking to the customer separately from their co-borrower if there are warning signs. And you can find those in the ABA and AFCA guidelines. So think about whether any of those warning signs were present at the time and whether they were missed by the credit provider. When you make contact with the credit provider, always request that the staff handling the complaint are specially trained in domestic violence and financial abuse. And you might want to request a case manager or a dedicated contact just to make the complaint process easier. Always check whether your client is eligible for any emergency financial assistance packages which some banks offer to their customers if they've experienced financial abuse. And if you do provide protection orders or other supporting evidence, make sure you don't send any unnecessary detail about highly sensitive information, especially if the staff receiving that information aren't specially trained in domestic violence. We don't want to unnecessarily expose people to the risk of vicarious trauma. So in terms of strategy, you would always want to ask for a moratorium, so a hold on repayments and interest and fees while you're reviewing the documents and preparing your request. Think about researching the creditor's public commitments. So see what they've said publicly about domestic violence and financial abuse and hold them to those commitments. Again, refer to their internal policies or ask for them if they're not readily available. And don't be afraid to remind the creditor of industry guidelines and AFCA's expectations of how they'll respond to certain complaints of this nature. In terms of protecting your client's confidentiality and safety, again, if you ask them to appoint a case manager or dedicated staff member at the financial institution, you can minimize having to retell your client's story and also avoid vicarious trauma to their staff. It's also expected that they'll assist the customer to protect their accounts and assets, and that they'll work with your client to change their PINs and passwords and things like that. They should make sure that no personal information is disclosed to the co-borrower. They should help remove any authorities that the co-borrower might have on the account. And as we've mentioned earlier, not require your client to make direct contact with the perpetrator. So if they say, sorry, we can't consider a complaint or a hardship request without the co-borrower's consent, then that's a big red flag and you should refer them to these industry guidelines. Now, the potential remedies for joint loans, we touched on this earlier, but you might be able to get the credit provider to agree to release your client from liability for the joint loan if they didn't get any benefit from it and the creditor missed warning signs of financial abuse. They might agree not to pursue your client for the loan, and they might also agree or should agree to remove default listings where you subsequently made them aware of the financial abuse.
Okay, this is our last substantive topic. We're close to the end, negotiating with debt collectors.
So when you make contact with debt collectors, as I've said earlier, always make sure you include the original creditor in correspondence because they'll probably have those originating documents like the contract, the application, the suitability assessment that the debt collector won't have copies of. Their job is just to try and pursue the debt from your client. And a lot of creditors actually have policies of recalling debts involving financial abuse. So if you make them aware that your client experienced financial abuse and other forms of domestic abuse, they might actually reach out to the debt collector directly and say, all right, we'll take it back and we'll deal with it and resolve it directly with the client. And that is echoed in AFCA's guidelines and their expectations. The benefit of that as well is that the creditor will typically have more favourable policies for your client than the debt collector will have. They're a little bit more advanced in their understanding of financial abuse, so you'll likely get a better outcome for your client. Now, when you're dealing with a debt collector, ask them to direct all correspondence to you or another advocate if your client doesn't have a secure email or mailing address. And your client particularly due to their experience of trauma and financial abuse, might be very stressed by any contact with the debt collector. The debt collection guideline does limit the hours and methods that they can use to contact people who owe debts, but it's currently silent on the issues of family violence and financial abuse. It's being reviewed and we've contributed to some submissions on debt collection issues, but their policies at the moment and their practices are not necessarily very sensitive to the experiences of domestic and family violence survivors. So the debt collection process can exacerbate trauma for people who've experienced domestic violence. They often send text messages or call from private numbers, which clients might be hesitant to answer. You can also request that you deal with a staff member at the debt collection agency who's specially trained in domestic violence, and always understand your client's rights and protections under the guideline, and don't be afraid to call them out on it if you think they're breaching those guidelines.
So finally, the question of when to get specialist legal advice and where to get it. Now, we covered this in the first webinar, so we might go fairly quickly through this.
Yeah, so very quickly, some urgent legal issues to keep an eye out for. If there have been court proceedings commenced, if your client has a statement of claim they haven't responded to, one step down the line, if they've got a default judgment already against them, clients might become aware of a garnishee order when they see money being taken out of their bank account or their wages. They might have a notice of default, or you might become aware that there's a time limit that's about to expire. Now, these are some examples of what specialist legal assistance can do. So these are all alternatives to taking, I guess, the quicker and sometimes easier route of bankruptcy or financial hardship assistance. So things that we can do are defending any legal proceedings that are currently on foot, applying to set aside the default judgment and kind of go back a step in the collection process. Again, seeking financial hardship assistance, negotiating directly with the creditor to repay the debt and avoid court proceedings. If there are any breaches of the credit law or any instances of fraud, then we'd be lodging a consumer complaint, in many cases seeking a full waiver or a reduction of the debt, or an agreement to release the client from liability. And if that's unsuccessful, then we'd be looking at complaining to an EDR scheme directly, so AFCA in most instances. So as I've said, these are all alternatives to bankruptcy. And if your service doesn't have the capacity and resources to untangle the debts that a client presents with and deal with them all individually, and your approach is usually to advise on bankruptcy at that point because of the volume of debt that's involved, that can really exacerbate the abusive experience for some clients. And it's worthwhile thinking about whether you do have the time and resources to untangle the debts and tackle them one by one. And if you don't, it might be better to refer the client to a specialist legal service rather than just dismiss it as financial hardship or take the bankruptcy route. And again, as we discussed in the previous webinar, these are our details for any referrals to our service. You can also refer clients to your local community legal centre or legal aid in your state or territory. And these are just some quotes from clients that we've assisted in our service, which show how much it can empower the client if you are able to take the time to untangle and address their debts individually, rather than taking a route like bankruptcy and really giving them the freedom to move forward and regain their financial independence.
Okay, so we'll work through the questions we've got. I realise some people may need to go, but we've finished the webinar proper, but we'll go through a number of questions that we haven't answered yet. So Shane asked, is there any protection for a client who has a buy now, pay later account where the partner purchases items on the client's account?
So we see this come up a lot even after the end of a relationship, where the partner might have enough of the client's personal information to open an account in their name or purchase items on their account without their consent. So if the client had no awareness of that and didn't consent to it, then buy now, pay later providers will typically require either a statutory declaration or a police statement to that effect, because it is an instance of fraud. And once you raise a complaint with the buy now, pay later provider, they'll advise on I guess, what evidence they require to satisfy themselves of that. And in many cases, once they've got that evidence, they'll agree to waive the debt.
Okay, Julie asks, a joint loan, client had no knowledge of it, partner fraudulently signed the client's name on the loan application. What are the resolutions to seek with creditors? So
again, if that's a situation where the client is now jointly and severally liable for a debt, but they didn't have any awareness of it at the time and they didn't sign the application, then you'd be looking at the credit provider's awareness of that and whether they actually made reasonable inquiries at the time and verified both the application and the information provided by the partner. That's a fairly good case of fraud, and one where you'd be pulling all of that that evidence together and making a complaint directly to the credit provider. And in terms of remedies, as I mentioned earlier, seeking a release of liability, seeking possibly for the credit provider to refinance the loan solely in the other person's name.
Okay, Amanda asks, I'm not quite sure how to get the grammar right here, but the 6 years from reasonable expecting to know of loss is what she wants to ask about.
So I think this is in relation to the time limits for AFCA. So in other cases, the time limit will be 6 years from when the client was aware of the loss or could reasonably expected to have been aware of it. AFCA did have a period following the Royal Commission where they were accepting legacy complaints. That period recently ended a couple of months ago, but they are more flexible in their complaints that they'll accept and in their time limits than a court, for example. So if it's a case where your client didn't actually know about certain mortgages or loans or what was going on, and they've only recently become aware of their financial situation, particularly if it's because that information was withheld from them in an abusive relationship, then I'd be encouraging you to push on with a complaint to AFCA and wait for them to give you guidance on whether they see it as being outside their jurisdiction.
Okay, Jody asks or says she has a number of clients who've been through a property settlement and are unable to get a mortgage because of their credit rating. Is there anything that can be done about their credit ratings where there's been domestic violence?
So what you'd be doing in that case is looking through the client's credit report with them and getting them to identify there might be inquiries on there that they didn't actually make, that they don't recognise. There might be debts with awful repayment history or default notices that have since been dealt with. But they're examples where you might be able to approach either the credit provider in the first instance or the credit reporting agency. Explain the circumstances of financial abuse and domestic violence and see whether they'll agree to remove that adverse credit information. And you'd be referring them to the AFCA guidelines on best industry practice in that respect.
Okay, Jody asks, could clients contact the lending institution afterwards to ask for the removal of the default listing, or is it too late?
So I think we've just addressed that one. Default listings will stay on the credit report for 5 years. So if it's coming up to 4.5 years, you might be thinking it's not worth the trouble and it will just drop off. But if it is impacting the client's credit report negatively, then you can approach the credit provider down the track and ask them to agree to that. As we mentioned earlier, it's not a legal obligation, but you might be able to find inaccuracies in the credit report, in which case it is a legal obligation to remove inaccurate information.
I think Fran's got a really good question that goes to the heart of the purpose of the webinar, really, which is we have a lot of non-lawyers working around some of these issues. Fran's a social worker and asks, or says she might have helped a client to make an application for financial hardship, but would it be better to recommend that they go to a community legal centre first to support them to do that? What's your view as a solicitor on what's the best pathway?
So my view as a solicitor who sometimes gets these matters when it's too late or when it's much further progressed down the line is if you are looking at the situation and you've talked to the client a little bit about how they got into the debt in the first place and how the credit contract was taken out, if anything smells off to you, or if you think, going back to that slide, if you think that maybe they couldn't afford it at the very beginning when they took out the credit contract, as opposed to just, losing their job or some situation happening down the line that put them into financial hardship. If you think there are any question marks over whether they should have been given that contract in the first place, even just a whiff of it, then I would always suggest that you refer them to get some legal advice about their options first. We can make that kind of assessment, get the necessary documents, and then we might say, look, having reviewed it, we don't think there are any legal claims available to you, and this is a situation of financial hardship, and we can bounce the client back for you to assist them to make that request, or a financial counsellor will often make that request for hardship assistance.
So I guess that answers Fran's second question.
So your second question of could I expect a financial counsellor to have this knowledge? That's right. I think if it's a question around responsible lending or any other legal claims, I would be referring to a CLC or a lawyer. But if it is just looking to get the best outcome through the financial hardship process, then you could look to a financial counsellor.
Someone else asks, do you have any suggestions to avoid post-separation financial abuse and fraud by a party using financial disclosure information to set up financial services in the other party's name without their consent?
So that's a good question. I think you'd be looking at what sort of financial services they could be setting up using that information. And I guess the problem with that is where we've got so many applications being done online, in the absence of, documents being signed by the borrower, or having any contact, for example, in, a branch, or having face-to-face contact with staff. So in those circumstances, I'd be looking to secure the client's financial position as much as possible. So think about, if there are joint accounts or have been joint accounts, changing their PINs, their passwords, internet banking, checking their credit report regularly. You can get your credit report from each of the 3 credit reporting agencies once every 12 months.
And we covered that in the first webinar.
Exactly, which we covered in detail in the first webinar. So a good idea is to get into the habit of doing that every 12 months. And that way your client can check whether there are any new inquiries they don't recognize, and then reach out to those financial service providers to see what on earth that's about and where the application came from.
Okay, I think this is our last question. Christine asks, do we have any templates for family and domestic violence letters for hardship?
So we don't have any templates that are publicly available, but there are a lot of resources online. If you look at the Financial Rights Legal Centre, they have some great templates where you can fill in bits and pieces of information, and it will spit out a letter for you. So definitely have a look at those if you're looking for some kind of pre-prepared templates to get you started.
Financial Rights Legal Centre, I'm trying to remember if they're listed in our resources. Possibly not.
We can pop them on there, or you can Google Financial Rights Legal Centre or the National Debt Helpline, and it will take you to them.
Yeah, but we'll get that added a bit later today to the resources page. Thank you so much, Jasmine. That was intensely comprehensive, can I say?
Thanks, Nick, and thanks everyone for all your questions. We had a great level of engagement, so hopefully you all found that helpful.
Yes, and just in terms of housekeeping, the slides will be available in about an hour. I'll email those to you, and they will be uploaded onto the resources page that's on your screen at the moment. The recording will be available. I'm thinking it'll be available by tonight on that same page, but if I face some technical issues, there could be a delay, depending. But you'll also see on that page, the recording of the first webinar has been there for a few weeks, and the PowerPoint of the first webinar is there at the very bottom of that page. So once we get today's recording and PowerPoint up there, it will be a very detailed and comprehensive resource for community workers and financial counsellors and lawyers on financial abuse. So thank you, Jasmine. It's been a whirlwind of information and guidance to the community in New South Wales and across Australia. So, and thank you everyone. We'll end the webinar now.